Colin Todd is one of the leading experts in the UK on fire safety law. He and I have been closely working together in the last case, the case of Foster, involving a double fatality, and his input as an expert was crucial to this case. We're very pleased that he continues to be associated with the Red Lion Chambers Fire Law team, and this video that you're about to see is particularly instructive about the need for experts and their importance in a case. Just tell us about how you came to become an expert and to run a firm that deals and specialises in fire safety.
I began my career with a degree in physics, and then I was one of the first 4 students in the country ever to undertake higher education in fire safety engineering, and that was a master's degree which I undertook in 1975. Following that, I worked in industry on the periphery of the insurance industry, providing technical guidance to insurance companies for a major insurance broker in the city. And then in 1982 I set up my own consulting practice to provide specialist advice on fire safety to the business community. As well as advising the business community on matters pertaining to fire safety, a significant part of our work is training, specialist training, quite often for enforcing authorities such as the Fire and Rescue Service. For example, in Scotland, for the past 5 years, we have been contracted by Scottish Government to provide specialist fire safety training for all Fire and Rescue Service inspecting officers in Scotland.
What is the job of an expert?
The role of the expert witness is to act as a servant of the court, and in particular not to act as an advocate for either party in the case. In that respect, the role of the expert is actually quite simple, because the expert gives an independent, unbiased opinion on the evidence put before the expert and answers specific questions put to the expert by counsel for one of the parties.
Do you act for prosecution and defence?
Yes, both. And in many ways it makes very little difference for the reasons I've just explained.
How important is it in a complex case, would you say, for one of the parties, prosecution or defence, to instruct an expert? And at what stage do you think that instruction should take place?
I think there's a clear dividing line between the role of the legal experts and that of the expert witness. In a complex case, some of the technical issues may indeed be quite complex in relation to interpretation of fire safety codes, with an insight not just into the letter of the guidance or codes, but in the underlying thinking and the principles that underlie the guidance in codes.
Tell us, what is a fire risk assessment?
A fire risk assessment is required by legislation across the UK and is basically a structured look at fire precautions in the premises, taking into account the nature of the premises, the nature of the occupants and the risk to life in the event of fire. The ultimate outcome of the fire risk assessment is to formulate a suitably prioritised action plan to address hazards and risks identified in the course of the fire risk assessment.
Some people might say that a fire risk assessment is simply a piece of paper with ticks and crosses on. Is it more important than that?
Yes, some fire risk assessments do tend to have a tick box approach, but such a fire risk assessment will rarely be suitable and sufficient. There has to be sufficient information associated with yes-no answers, for example. And a view I often take is that the risk assessment will be suitable and sufficient if someone can audit it from start to beginning and inexorably be drawn to the same conclusions from the information available as the risk assessor.
In terms of seriousness when it comes to a criminal prosecution, how serious is it not to have a fire risk assessment for your business?
As long as the fire precautions in the premises are adequate, the absence of a fire risk assessment may make little or no difference. The problem arises when no one has been addressing fire safety in the premises for some time. And then the fire risk assessment is absolutely critical. It is the underpinning for ongoing management of fire safety in the premises. And its absence may then result in risk of death or serious injury to relevant persons, anyone who occupies or visits the building. And at that stage, then an offence has been committed under the legislation.
Colin, I think you were instructed as an expert in a recent case involving a double fatality, in which it was suggested that a risk assessment went to the heart of fire safety. What was your involvement in that case?
Yes, I acted as an expert witness for the prosecution, and my role was to advise the court as to whether, in my opinion, the fire precautions were such as to breach the requirements of the Regulatory Reform Fire Safety Order, to advise as to whether, in the event that the court determined that there was such a breach, the breach resulted in the risk of death or serious injury of any occupant. And then, more specifically, my instructions required require me to give an opinion as to whether the deaths of the two young persons in the premises would have been significantly less likely but for the breach.
Colin, shortly after your expert's report was served in the double fatality case that you just told us about, there was, I think, a dramatic change in the future of that case. Is that correct?
Yes, I think that's correct to say. My understanding is that until the report was served, the defendant was maintaining a position of not guilty and was intending to enter a not guilty plea. After the report was served, the defendant changed his position and pleaded guilty to a number of offences.
And in fact, the sentence was a record sentence when it comes to fire legislation and convictions, isn't it?
Yes, that's correct. The sentence imposed by the court was one of 12 months imprisonment, and that was actually a discounted sentence for the guilty plea. Our understanding is that that is the longest custodial sentence ever awarded in the history, really, of fire safety, modern fire safety legislation.
Colin, apart from cases in court, prosecutions in court, are there any other aspects of fire safety that you get involved with?
Yes, there are. The fire safety legislation facilitates determination by the Secretary of State if, in the event of a breach of the Regulatory Reform Fire Safety Order in England and Wales, there is a dispute between the enforcing authority and the client as to the appropriate technical means for remedying the breach. There have been 4 such determinations by the Secretary of State in England and 1 in Scotland to date. I've been involved with 2 of the 4 determinations in England and Wales, in which the Secretary of State found in favour of the client and determined that the action required by the Fire and Rescue Authority was not in fact necessary.